If you had $360,000, then you can be in my court. Well, it's not your court, Your Honor. It's Congress's court, and this is where they said to be. Because it does not take much, and I keep reiterating this, to be smarter than the attorney on the other side. It doesn't. Just a little bit of knowledge goes a long way, and you'll get better settlements and better results. But on the same day, IQ Data also sent a debt verification letter directly to SIX. So that's a violation of the law right there. You send it to the attorney. Otherwise, it's meaningless to have a congressional created statute under federal law saying don't do that. Hey everybody, it's time for another exciting video. This one's a good one. I have many topics I can do to help you. Once in a while, I like to kind of look over the fence and go into other districts. Like we just did a case for a client who basically did the whole video for us from Washington State, which is the 9th Circuit Court of Appeals, Federal Court of Appeals, one before Supreme Court. I have not made it to the US Supreme Court. I've gone as far as one level below. It's a circuit court also. It's the 6th Circuit Court of Appeal. Today is the 9th Circuit Court of Appeal, and it's a great case. I like to do these opinions every once in a while, opinion case studies, because they have a direct impact on how I function as an attorney in the field of FDCPA and what you can do and how educated you could become under the FDCPA, because it does not take much, and I keep reiterating this, to be smarter than the attorney on the other side. It doesn't. Just a little bit of knowledge goes a long way, and you'll get better settlements and better results. So one case in particular I looked at, I've titled it, Making a Federal Case Out of a Single Letter. That expression, hey, don't make a federal case out of it, it permeates how a court looked at today's case and today's plaintiff in a rather rude way, and I'll explain that further. So, would you make a federal case out of receiving one letter? Now, I said previously that I appeared in a federal district court case for the chief judge for $364. In a federal court that handles the biggest cases, presidents, senators, titans of industry have to go through federal court when they get in trouble. I was there with my $364 debt, and the judge looked at me and said, how dare you bring this nonsense to my court? Why are you here? And I just scared. I just said, because Congress said I'm supposed to be here. And that's where the FDCPA lives and breathes. It is a federal question, a federal statute created by Congress. And so every case that's a federal statute generally belongs in federal court. And the $364 part of this is important in this case as far as the kind of case versus degree, meaning degree would be you've got to have more damages. If you had $360,000, then you can be in my court. Well, it's not your court, Your Honor. It's Congress's court, and this is where they said to be. So, but the kind of injury to, in that case, my client that time, was the breaking of or violating of the law, not how much he suffered. So, with that in mind, let's look at the case of Ryan 6 versus IQ Data International, Inc. It's right up there. It is 23-15-887, 9th Circuit, Feb 24, 2025. That's the appeals court designation. So here's what happened. Before I go any further, there's only going to be really one document. They're all going to be good, but one you're going to love to have, and that's the FDCPA checklist and cheat sheet that's attached to this video at killdebt.com and also embedded in ParkerGPT for you to have at the click of a mouse. There'll be the appeal decision from the 9th Circuit Court of Appeals, an order from a district court that had to be appealed. And that's the order and that judge where I'm going to show you a quote that he said, and I'm going to say to you, which way do you think he's leaning? So the plaintiff's response to a summary judgment motion will be attached. The plaintiff's own motion for summary judgment. Based on that letter, he filed his own saying, what's the problem? What's the problem here? It's obviously a violation. I should win. And again, the judge ruled, you'll see. A federal lawsuit that went up to the Supreme Court that is only 4 pages long. So this is based upon a letter, and all that they did was a 4-page federal page. You think federal law, so ooh, exhibits, pages, people in robes. No, 4 pages. So let me set the stage for you. I'll put it up. Shazam. Ryan 6 had a debt related to a residential lease, very particular common thing, that was placed with IQ Data International. International, ooh, they're across seas. Anyway, here's the timeline. June 2021, IQ Data reported the debt on Mr. 6's credit. Love that name. August 18th, 6 mailed a letter to Equifax disputing the debt. That same day, 6's attorney sent a letter directly to IQ Data notifying them that 6 was represented by counsel. It's very important, and all communications should go through that attorney. Even if they don't say that, all communications must go through an attorney. I've written those letters. They all say that. From here on out, under the FDCPA, all communication or correspondence should go through my office. You don't have to say that once you say you're represented. You'll see why. August 30th, 2021, IQ Data receives the attorney's letter. September 2, 2021, IQ Data received 6's dispute letter and submitted an internal request to generate and send documentation to 6's mailing address. So a couple of days after they received the letter officially, they created a letter to send to him, which is interesting. If that's not in response to a validation letter, meaning their response should be validating the debt, you got an issue there. Why are you contacting him? You can't until under the law. It's 1692 GB says when you receive a letter in writing or a dispute in writing, you must cease and desist. September 3rd, 2021, IQ Data updated its records to show it had processed the attorney's letter, but on the same day, IQ Data also sent a debt verification letter directly to 6. So that's a violation of the law right there. You send it to the attorney. Otherwise, it's meaningless to have a congressional created statute under federal law saying don't do that. And that single letter became the basis of a federal lawsuit or a federal question. Here's the letter, Shazam. There's nothing you haven't seen already. I would say September 3rd, 2021, just 2 months later, the CFPB changed everything radically and changed those letters and created what's called a safe harbor letter, which ended up being really bad for consumers. I won't get into that, but if I had received this letter December 1st or December, January going on, I would have said that they didn't even send me the proper letter, but I digress. But the important thing is that's the letter that the gentleman received, Mr. 6. And then here is his response, Shazam. And that is from an attorney, and I'm here dangling with this stuff, and is the Credit Law Center. I point that out because here's the letter, and the important part is please update your files to note our representation. Please direct all communication in regards to the above reference client in our office via electronic correspondence and the address. So, and then it's a rundown of things that aren't really necessary in one of these letters or required. And a lot of times these letters go out asking for things that they're not required to respond to you with, but you got to load up on them because they load up on you. And the reason I point that letter out is in another video I did for you, it was called Ignorance is Not a Defense, New FDCPA Bombshell Case in the 7th Circuit Court of Appeals. And that involved a letter from the same attorney, Shazam. His name is Mr. Adelman. It's the Credit Law Center again for the plaintiff in that case, Mr. Wood. In that case, Mr. Wood had sent a dispute letter out. I'll just read it. Shazam. In that case, a debt buyer purchased the account unaware that the original creditor had already received a written dispute from the consumer. And after the reinvestigation, the creditor believed that they legally I think it's called under the bona fide error rule. It was not required to place the debt in a dispute status. If something's in dispute, you have to under the FCRA and FDCPA on the debtor's credit because the debtor didn't follow up. They literally made that argument. Yeah, he wrote the letter disputing it, but he didn't follow up. Well, there's no duty on your part, the debtor's part, to follow up. Hey, did you do what I asked you to do the first time? And so the debtor sued because it's appearing on his credit report without a dispute notification. And until it's handled, it has to have the dispute notification. Under 1692E8, you shouldn't put anything on someone's credit. That's the FDCA version of the FCRA version of the dispute rule. But the court in that case, just like in the case Mr. Six, dismissed the case in favor of the debt collector. The name of the case is Wood. Let me put it up there. Wood versus Security Credit Services, LLC, 25, F4th, 544, 7th Circuit. The court dismissed the case in favor of SCS based upon a lack of standing. That's important. Lack of standing, and concluding that the credit card issuer reasonably interpreted the lack of response to its letter to mean that it no longer disputed the debt. There is no rule that you follow up after sending a letter that doesn't get responded to. So, and the court said that SCS knew there's no proof that SCS knew or should have known that Mr. Wood still disputed the debt because he didn't follow up. He's not required to do that. On appeal, the 7th Circuit Court of Appeals held that ignorance of the debt collector is no defense. Under 15 U.S.C. 1692E8, a collector must report an account as disputed once it has reason to know a dispute exists. It came out that they did, even if the prior creditor failed to pass that information along. And this is important as we go along. I hope it may be boring. The 7th Circuit Court of Appeals stated concrete injury. I'm getting into standing and explaining that to you. Failing to report a debt as disputed resembles defamation and supplies Article 3 standing. Failing to mark a trade line disputed creates a reputational. I've argued those cases. I got a good class action going on in Florida based upon reputational harm. Creates a reputational injury analogous to defamation, a harm traditionally recognized at common law, one of which is the basis of my review of the case today. That analogy satisfies Spokio versus Robbins. Spokio was a huge standing case, happened, I'm going to say to you, 2019, that obliterated a lot of FDCPA cases, focusing on damages rather than the actual violation. And then a bunch of cases were passed, with the main one being TransUnion LLC versus Ramirez. That is the basis of the dismissal of today's case, and also the basis of how that today's case is appealed and won, even though the lower court said, because of TransUnion LLC versus Ramirez, I'm dismissing Mr. Six's case. But the Oregon, I shouldn't say Oregon, but it's in that area, the 9th Circuit Court of Appeals, one step below the Supreme Court, said, Ramirez makes it possible that he has a case. So both of those cases are based upon a very important issue if you want to get into federal court, and that's one of standing. So in this case, the subsection of the FDCPA is USC 1692C A2. Here it is. Shazam. Communication with the consumer generally, without the prior consent of the consumer, given directly to the debt collector or the express permission of a court of competent jurisdiction. A debt collector may not communicate with the consumer in connection with the collection of any debt if the debt collector knows the consumer is represented by an attorney. So that section says the debt collector may not communicate directly. Interestingly, we've talked about this in the past, may versus shall. I guess it could be argued that, well, it says may, it's just a suggestion. This is one of those cases where don't fool with the federal court. So this, meaning if it's a federal statute, may and shall essentially are the same. The section says that a debt collector may not communicate directly with a consumer if the collector knows the consumer is represented. In other words, if the debt collector says, well, it's not shall, it is still a violation if you contact. So the debt collector can go, yeah, it says may, I can still contact. If it said shall, then I wouldn't. But it's still a violation to contact, whether it says may or shall. So what does any of that matter? Because Congress, when it invented or created the FDCPA, specifically recognized, and this is important as we go along, Shazam, abusive debt collector practices contribute to the number of personal bankruptcies, to marital instability, it's all true, to loss of jobs, and to invasions of individual privacy. That's one of those common law, old laws that Congress based its codified kind of modern statute upon. So, and that is 1692A, and that is generally what the FDCPA is based upon. Before the FDCPA was created, there was a horrible problem with debt collectors just running over debtors, and there was no protections. So the court found as a basis for creating the FDCPA, abusive debt collection practices contribute to the number of personal debt bankruptcies, marital instability, loss of jobs, and invasions of individual privacy. So, the phrase individual privacy becomes critical to this case. So, in the district court case, Mr. Six sued in the U.S. District Court for the District Court of Arizona. So, the district court and federal court is the lowest level, but that's a very powerful court, regardless that it's on the third level or hierarchy. Presidents, senators, titans of industries have to all go through federal court and get their ears boxed if they do something wrong. That's where they go. But the district court, in this case, Judge Liberty dismissed Mr. Six's case. Now, I'm going to read to you the opening paragraph of the order that he wrote dismissing this case. I want you to ask yourself, hey, this sounds like a neutral judge, doesn't it? That's the question. Ready? Here's his first paragraph of his order. Shazam. Every day, millions of people receive unwanted mail, extend the warranty on your car, buy one, get one free teriyaki bowls, an upstart landscaper wants your business, and the like. Sometimes a collection agency sends a recalcitrant, I love that word, debtor, a letter asking for payment. Ryan Six, the plaintiff here, got one such letter and now wants to make a federal case out of it. How rude. The court is asked to rule on defendant IQ Data International Incorporated, IQ Data, and Six's competing motions for summary judgment, but doing so is not necessary because Six lacks Article 3 standing. The court dismisses this action for lack of jurisdiction. The district court, again, ruled that Six lacked Article 3 standing, meaning he hadn't suffered a real, concrete injury that federal courts have a power to address, meaning you can't go into federal court unless you got a concrete injury. So, quick primer on Article 3 standing, Shazam. Article 3 of the U.S. Constitution limits federal courts to resolving cases or controversies. To have standing, a plaintiff must have the following three things: an injury in fact, a concrete, particularized invasion of a legally protected interest. Causation, the injury must be fairly traceable to a defendant's conduct. That's reasonable. Redressability, a favorable court decision must be able to remedy the injury. The district court said receiving one letter was just a bare procedural violation and not a real world harm that courts can fix. So Six appealed to the Ninth Circuit Court of Appeals. So the court, before I get to the appeal, is saying he may have received the letter, but so what? It's one letter, and to quote again, it's not a real world harm, and it's a bare procedural violation. Come on. So the Ninth Circuit said, hey, wait a minute, we're reversing the district court's dismissal and held that Ryan did have Article 3 standing. Otherwise, in other words, a concrete injury that federal courts must address. So it used, sometimes courts talk to other courts, if you read between the lines, they're kind of, how about that? And they used this TransUnion and Ramirez test against the district court. Now when I say against the district court, because guess where this case is now? Right back at the district court level. And now I've done that. I've appealed and won cases, and I can't wait to get back down to that judge that I knew was wrong. And I've yet to do what the little boy inside of me wants to do. You know what I'm saying? How you like me now? But no, you can't do that. You got to respect the bench. So at the district court, the judge had dismissed the case based upon standing and the case of TransUnion versus Ramirez. And that Article 3 of the U.S. Constitution confines federal court jurisdiction to the resolution of actual cases or controversies, citing Spokio versus Robbins. However, the Ninth Circuit applied a two-part test from TransUnion versus Ramirez, and here it is. Part 1, Shazam. Courts look to whether a Congress identified the alleged harm as worthy of legal protection. Remember, the statute has been created. It's the FDCP, I think it was 1986, and they said because of certain reasons they're creating this to protect debtors, and one of the reasons to protect invasions of privacy. Congress's judgment is instructive because Congress is well positioned to identify intangible harms. So there's a little fight going on in the courts right now. Tangible versus intangible harms. My feelings of hurt would be an intangible harm. For example, a tangible, hey look, there's a cut on my arm. You can see it. So is reputational or mental distress, which is an intangible harm, meaning you can have a reason to have standing in federal court. Here, Congress expressly recognized in the FDCPA that the Debt Collection Practices Act, the violations can invade individual privacy, and it specifically prohibits collectors from contacting consumers known to have attorneys. So, part 2, historical or common law analog. Courts ask whether the plaintiff has identified a close historical or common law analog, meaning a harm traditionally recognized as providing a basis for a lawsuit in American courts. The issue here is, the issue doesn't need to be an exact duplicate. It just looks like a similar harm, but not a similar degree. So if you can say, yes, it's one of those 4 protected common law analogs that are pervasive in American history, if it's 4 of those common laws, then we're going to say, if that's violated, we're not looking how many letters were sent, the degree, whether it was intangible or intangible. We just have to show if we're not really looking for a concrete injury. Concrete injury definition or standard is met if the harm is one of those 4 things. Let me show you what those 4 things are. Well, the Ninth Circuit found that Six's harm was closely related to the traditional common law tort of the intrusion upon seclusion. So that was one of those 4. So what is intrusion upon seclusion? Here we go. It's one of 4 traditional privacy torts in American law. It protects an individual's right to be left alone and undisturbed. There's an actual right to be left alone. Quick side note. I was going out with this Russian lady, nice, and she was always upset about something. Maybe it's just me. But I tried to make her laugh and make her happy. It was a month long, and I'm like, I don't want to keep doing this. And my final approach was, you know, it's an American law that you have to be happy. And she's like, what are you talking about? I said, in the Constitution, it says we have a right to happiness. There's an actual right in the Constitution. So, you know, enjoy your rights if this new country you're in didn't work. So anyway, one of those torts You generally must prove intentional intrusion. The defendant, remember we talked about elements? If you knock out one element, you knock out the whole case. So here's the elements of intentional intrusion. Intentional intrusion, intrusion upon seclusion it's called. The intentional intrusion. The defendant intentionally intruded upon plaintiff's solitude or private affairs. Number two, highly offensive intrusion. The intrusion would be highly offensive to a reasonable person. So there's two kinds of people. There's a subjective approach and a reasonable person's approach. Is it reasonable to that every reasonable person, the average person, would suffer the same as a result of the harm coming their way? It isn't a subjective standpoint where you look at the person and say, is it bothering you? But you're looking, in the FDCPA is about regulating the debt collectors, not the debtors. And number three, private matter. The intrusion was into something with a reasonable expectation of privacy. The Ninth Circuit said that when 6 notified IQ data of all communications going through his attorney, he clearly expressed a desire not to be disturbed. By sending a letter back to him, IQ data created an irritating intrusion on 6's privacy and peace. Again, I'm not making any judgments as the court at the district court level did about the frequency of letters and hey, it's just a letter, but that's the law, okay? The Ninth rejected the Seventh Circuit's approach. They had filed a case called Puccello versus National Credit Systems. The holding in Puccello, I'm gonna butcher that, Puccello, said postal mail can be picked up when and if and how often the recipient chooses, unlike a phone that's always with you. But the Ninth Circuit said, Shazam, Puccello's analysis focused on the degree of harm rather than the kind of harm. And the Supreme Court has counseled against this approach. Taking Puccello's logic to an extreme would mean that even someone who received hundreds of unwanted letters couldn't establish standing just because they chose when to pick up the mail. That can't be right. The Ninth Circuit also noted nothing compels a person to look at text messages at unwanted times either. You can choose when to view text just like you can choose when to get your mail. So the Puccello case would not apply. So this court, this district court, lower court in Arizona said, hey, don't make a federal case out of this. Well, guess what IQ data did? They applied for an appeal to the US Supreme Court over this single letter. So is anybody smacking them and saying, hey, you're making a federal case? And so the Supreme Court of our United States on October 6, 2025. So the Supreme Court in their certiorari list, gosh, I'm screwing everything up today. I'm going to show you what a certiorari list looks like when a court decides, or a Supreme Court decides whether to take a lower court case or not. Shazam. And under the title certiorari denied, you can see the 24-13-26, that's the appeal. IQ Data International Inc. versus 6 Ryan is denied. So what does that mean? It means the following. If you're represented by an attorney and a debt collector contacts you directly, even with a single letter, you may have an Article 3 standing to sue under the FDCPA in the Ninth Circuit. Let me show you that map, Shazam. You can see the orange there. That is the Ninth Circuit. It's quite large. They send a lot of cases to the Supreme Court. They and I think it's the Fourth Circuit, which is really called the rocket docket because they move so fast, send probably most of the judges to the Supreme Court more than any other district. I practice in the 11th, which is that gray. I also practice in the 6th, and I've practiced I just did a case in the 5th. He said it's quite large. I get around. That's 30 years. So the harm is the intrusion itself. You don't have to show additional damages. Like, for example, hey, look, my credit score dropped. That letter is enough, and you can make a federal case. So debt collectors, they need to have immediate processes in place, because I want to show you what happened in this case. So this is the complaint. Let me show you the 3 or 4 pages that were the basis of this complaint. Shazam. And you can see there's nothing to this lawsuit. That's a federal lawsuit. And I have my theory why that is. The letter that came from the Credit Law Center was a form letter, and I think they expected that would be the end of it. Nothing happened, so they hired another attorney to go fight this, and this IQ data came in blazing. I think in some cases, debt collectors pick certain cases to make a federal case out of, because they see a federal court, Supreme Court right now is very pro-business, and they pick cases. I've had one of those cases where I'm like, whoa, we're all off the way up the line. And I'm like, why are we doing this? It's a simple case. They pick cases when they know the time is right, so they can get a decision out of a particular court that they know they can use for the next 10 or 15 years to just slam. It's a very calculated, expensive decision. This case, it's gone on for 4 years over a single letter, by the way. So let's just take a look at the allegations 13 through 20. In June 2021, defendant reported the debt on the credit reports. There's a list there of what they did. Look at 15. Defendant received the August 18, 2021 letter on August 30th. In response, the answer was the following. Defendant's answer was, IQ Data admits the allegations. However, IQ Data firmly alleges that the letter dated August 18th from counsel for plaintiff was processed by an IQ Data employee and added to the relevant file on September 3rd. So what they're saying is, yeah, we sent a letter back with that, not to the attorney, but to the plaintiff in this case. But it wasn't our fault, it was some employee at IQ Data. So we're off the hook, right? No, they received the letter. That's the issue. And in that video I was telling you about on the 7th Circuit I did, let's put it up there again, Shazam, that same excuse that whoops, was the wrong designation or a wrong employee put the wrong thing in this is the same excuse they used in that circuit court opinion, and the court wasn't having any of that either. It's just amazing to me that debt collectors get away with such nonsense at certain court levels, and then when you reach an appellate level where those people think for a living, suddenly all that nonsense and BS that you've been pushing away going, are you serious? And then a judge goes, yeah, they're right, and it's nonsense. But when you get into intellectual people, if you will, they can see through all that stuff the same way you already see through that. But that's what happens. That's why stuff goes up on appeal. So the conclusion here is Ryan 6 received one letter. The judge made fun of his letter and making a federal case out of it. The district court said that wasn't enough. The 9th Circuit said IQ Data was wrong, and yes, they shouldn't have sent the letter, and they received the letter well before September 1st when they sent their letter. And the Supreme Court ruled even better by saying, yep, we're not getting involved. So the lesson, when Congress says debt collectors can't contact consumers who are represented by attorneys, they mean it. And that single letter, it absolutely can be a federal case. So this is all education and a little bit of fun, but I hope you learn from it. Like, love, and subscribe and share. And I now, because you've made it this far, I'm going to put up a coupon code to get 10% off killdebt.com with our AI-powered ParkerGPT. How do I forget my own name? ParkerGPT. Shazam. Enjoy. A lot of people have taken advantage of that. You made it this far with this nonsense. Congrats. But take this case and use it in your own work, because there's bits and pieces for people here. Even though it's talking about federal court, these are rules that I use in 99% of my state practice to fight off the bad guys. I hope you can use them too. Thank you.